Okay, good afternoon, Jon Sharp. How are you?
I'm well, Julie. I see you're in the office then.
Indeed, indeed. Safely socially distancing, rest assured, it's not an issue.
Good, good, good. I'm glad to hear it. Glad to hear it.
Okay, I understand there's been some updates on the FCA test case that you've mentioned earlier. Just to sort of get some clarity on this, because I know it's quite an important one for everybody. Has the FCA test case now concluded?
Yes, Julie, it did. It started bang on time on, I think, the 20th of July, and it finished on the 30th. It was a very unusual case from a practitioner's point of view, as it was mostly done by video link, Zoom links, etc. And there was a vast array of counsel. I've tried to add up how many counsel were actually present, but it's got to be close to 20.
Ooh.
And 2 judges. So quite hats off to the judges who had to deal with 20 barristers. But I suspect it was all done. If it finished on time, it must have all been done very orderly fashion. As people know, this case is exceptionally important because of the business interruption clauses in most people's office combined policies, etc. The FCA, they have to be commended for this, brought the case because of the uncertainty surrounding the case, the approach of insurers, which to date has been COVID-19 has got nothing to do with us. And the FCA brought the action effectively on behalf of policy holders. It primarily concerned really just 2 issues. At its heart, it's 2 issues. Infectious disease extensions in business interruption cover. So in what circumstances can businesses claim under this head? And the second one was prevention of access extensions. So this is where you have a clause in the policy that says, if your premises are shut down by a government body or local authority, you can have a business interruption claim. Shortly, at its heart, that's it. Those were the 2 questions. Now, normally when you have a case where interpretation of a policy wording is required, it's normally an agreed set of facts. Here's the policy wording court. What's the ruling that you're going to give? This was slightly different because it was based on an assumed set of facts, and some 8 insurers with, I think, 27 policy wordings basically appeared before the court to give their opinion as to what the policy wording means, and the FCA stood up and said, no, I'm afraid that's not right, you've got to pay, etc. So those are the only 2 main issues. However, I can expand a bit further, Julie, I think.
Okay.
If I can expand a little further, I'll just refer to my notes because these were the other policies that these are the other issues that the court looked at. So basically, what steps of the UK government or other bodies constituted actions, advice, or restrictions? What effect on the business is required for it to be considered to be interrupted, or for there to have been a prevention or denial of access, for example, whether it requires total closure or whether significant curtailment is enough, such as the restriction of vendors to takeaway or online delivery services. Is that sufficient? What does it mean if a policy requires the disease to have occurred in the vicinity, at the premises, or within a certain radius of the insured premises? What evidence is going to be required for a policyholder to demonstrate the occurrence of COVID-19 within the necessary radius? For example, can it be inferred from average levels of COVID-19 in an area of the UK, or is it laboratory confirmation or medical diagnosis? Now, there are, as in all policies, a number of policy exclusions. Which, if any of these, apply? What is the necessary causal link between the policyholder's loss and the interruption to its business, and the interruption to the business and the action advice of a relevant authority and or the emergence or occurrence of the disease. The implication of what's called trend clauses, which adjust the calculation of lost income recoverable under a business interruption policy on the basis of wider trends that may have affected the income of the insured business over the period of interruption for causation and quantification of loss. What that's getting at is, in normal circumstances, so say you have a fish and chip shop, it catches fire.
Yeah.
The insurance policy would normally pay out for, obviously, the repairs to the premises, but also would pay you a sum of money for your loss of profit, basically, whilst your business was shut. But if nobody was coming to your business anyway, because of the government action, what loss have you suffered?
Yeah.
So that's going to be interesting. And that actually goes on to another case. There is only really one leading case on the whole of this. And that's a case called Orient Express Hotels Limited against Assicurazione Generale SPA, an Italian insurer, I suspect. That looked at this question really. If there are more than one potential causes of loss, which are concurrent and independent, then what is their effect on recovery? Now, in the case I just referred to, it was found that the policyholder, it was all to do with a New Orleans hotel. New Orleans hotel was damaged by a hurricane, fine. But as we all know, all of New Orleans was damaged by the hurricane. Horrendous losses everywhere.
Yeah.
So where it was found in that case that the policyholder could not claim in respect of the loss of income caused by physical damage to their New Orleans hotel, because applying a but-for test, that damage could not be said to have caused their loss when, in any case, the whole of the surrounding areas had to be evacuated.
Yeah, makes sense.
So those were the additional matters that were looked at by the court in relation to the whole COVID-19 situation. So there we go.
Okay. So when can we expect the decision? There's not going to be any...
When can we expect a decision? Well, the court is being very, very careful. It is right to say that it's been calculated that there are some 700 types of policy and up to 370,000 policyholders potentially affected.
Wow.
So the court, not unreasonably, has said we need to get this right. So, as I mentioned before, certainly one of the judges I instructed before, he's an exceptionally intelligent man. And he's saying, look, I'm going to have to sit down carefully and think about this. Yeah. So they're very reluctant to actually say when they're going to give their preliminary judgment on this. They're indicating 30th of September, but undoubtedly there will be an appeal which will leapfrog the Court of Appeal and go straight to the Supreme Court. Yeah. So finality, I don't expect to see until, I said in previous vlogs, 30th September, I'm not realistically expecting now to see that until I would have thought end of October.
Right.
So what should people be doing in the meantime? Well, I think as I've said before, you must have notified your claim.
Yeah.
If you haven't done it by now, I suspect you are going to run into big opposition from insurers who will say this is late notification.
Yeah.
You know, it's now 4 and 5 months down the line. You should have notified your claim.
Yeah.
However, I still think it's worth notifying. If your policy has either infectious disease cover or some form of closure by government or local authority, make a claim. Now that will probably be rejected by insurers. And this is the other little trap that people are falling into. They don't respond to that. You must respond.
Right.
Even if it's just an email saying, thank you very much, we don't agree. As you know, the case is in court at the moment. We're going to wait for the outcome of that those proceedings. And in the meantime, all of our rights are reserved.
Right.
Sometimes people also panic because they get a letter from their insurers saying, if you don't agree with our decision, you can go to the the Financial Ombudsman Service. That's fine. Don't go running off there yet, because certainly if you use solicitors to do that, there will be a cost to it. And again, this case may obviate the need for you to do that. But do not panic, because you've got 6 months in any event to go to the Financial Ombudsman Service. Also, what's been happening is that insurers have been writing to those who make claims and saying, well, this FCA test case, it's not really going to apply to you. You haven't got that sort of policy, mate. You haven't, honest. Well, yeah. The response to that is, well, thanks very much. Not sure that you have actually interpreted what the case is covering accurately, and therefore all of our rights at the moment are reserved until we have the outcome of the case. Okay? You don't want there to be any arguments about, oh, well, you accepted what we said. Make some form of response. It doesn't need to be particularly long or detailed. Just get something there.
So don't panic.
Lastly, make sure. I'm sorry, Julie?
I said don't panic, but do respond.
Yes. Lastly, make sure you keep accurate records. It goes without saying that you are going to have to justify what you have lost. Insurers, if they are found to be liable for this, their next attack will be quantum. They will be saying things like, well, what loss did you actually suffer? Can you prove you lost that? Can you do this? Can you do that? Unless you've got the records to support it, you are not going to do very well. So you need to be keeping full and accurate records of all of your losses that can possibly have arisen out of this COVID-19 situation. So there we are. As I said, I will do another update when I've got something more detailed to report. If people do want to know more about this case, then again, FCA to be applauded. All of the pleadings, everything are on their website. So you can look for yourself and see what issues are going to be decided. It's all there. And the FCA are also putting on their website regular updates as to where we are with the case, etc. So you do need to know more, or you want to find out more about the case, then that's the place to go. As I said, the FCA must be applauded for that. It's been very transparent. Indeed, I think you could actually pay to have a live link to some of the proceedings as well. So it's been a very transparent process. And the FCA, as I said, I think they must be commended for being as straightforward and as transparent as they possibly can be. Right. What the likely outcome is? As I've said before, I am still very much of the view that Jeffrey Gruder is right. Because nature does not operate in watertight compartments. A virus cannot be compartmentalized into, well, it was there, but it wasn't here. It was there over there, but it's not here. I don't think that really works. It'll be interesting to see what they say about the closure by the government, local authorities, etc. But I don't know. It's going to be a close one, I think. I don't think there is an answer one way or the other, but I think there will be some positive findings for the insureds, but quite how far they'll go is a different matter. Anyway, Julie, that's all I was going to say. So I hope that's been useful, and I look forward to seeing you in the flesh very shortly.
Indeed. Thank you very much, Jon, for that update. It's always fascinating to hear the latest instalment in this gripping saga. We look forward to the decision whenever that may be. Thanks, Jon, and we'll speak to you soon.
Yeah, take care, Julie.
Take care. Bye-bye.
Bye-bye.